Today, I'm talking about technology integrations. They can create real business value. They can expand product functionality, improve access to useful data, and open new distribution channels. But they can also create legal and operational risk if the contract does not reflect how the relationship will actually work. That is especially true in health tech, where integrations often involve sensitive data, regulated workflows, and valuable intellectual property. So before moving ahead with an integration, there are a few legal issues that deserve close attention. First, make sure the agreement clearly describes the deal. That sounds basic, but it is a common problem. A draft agreement may talk generally about an integration without clearly stating what systems are connecting, what each party is responsible for, how implementation will work, or what the parties plan to do commercially once the integration is live. If the contract is vague at the start, it becomes much harder to manage expectations later. The agreement should clearly address the scope of the integration, each party's technical and operational responsibilities, and the business model around the relationship. It should also deal with practical terms such as term and termination, support expectations, and what happens if the integration changes or ends. Second, focus on intellectual property. In many integrations, one or both parties are providing access to proprietary technology, whether that is a platform, software, API, algorithm, workflow, or other know-how. The contract should make clear that each party retains ownership of its pre-existing intellectual property. It should also define the license rights carefully. That includes questions like, is the license limited to internal use? Is sublicensing permitted? Are modifications allowed? Can one party use the other party's technology only to support the integration or for broader commercial purposes? Those details matter because a broad or unclear license can create competitive and ownership problems over time. Third, pay close attention to data rights. Many technology integrations exist in part to exchange, access, or process data. In a health tech context, that issue can quickly become central to the deal. The parties should be clear about what data is involved, why it is being shared, and what each party is permitted to do with it. For example, the agreement should address whether data may be used only to provide the integration, or whether either party may also use it for analytics, service improvement, or other secondary purposes. It is also important to think through restrictions on disclosure, retention, deletion, and any use of de-identified information. If those issues are not addressed clearly, the integration can create compliance risk as well as commercial tension. Fourth, address HIPAA and broader privacy and security obligations. If protected health information is involved, the parties need a legal structure for the exchange and handling of that data. Depending on the roles of the parties and the services being performed, that may require a business associate agreement and related HIPAA compliant terms. The key point is that HIPAA analysis should be done carefully and based on the actual function of the integration. And even when HIPAA does not apply, privacy and security review is still important. Personal information that falls outside HIPAA may still be subject to state privacy laws, contractual privacy commitments, and security requirements. The parties should also address reasonable safeguards, security incident responsibilities, and notification obligations if something goes wrong. Finally, do not treat the risk allocation provisions as boilerplate. In technology integration agreements, clauses like indemnification and limitation of liability can have a major impact. The parties should think carefully about who is responsible if there is an IP claim, a privacy issue, a security incident, or a failure in the integration that causes harm. Termination rights also matter. The bottom line is that a technology integration agreement should do more than confirm that two systems will simply connect. It should accurately capture the business arrangement, protect each party's intellectual property, and define data rights, address privacy and security, and allocate risk in a realistic way. One final point. This area is continuing to evolve. In particular, companies are paying much closer attention to state privacy law compliance, AI-related data use restrictions, cybersecurity obligations, API governance, and what happens to data and customer relationships when an integration ends. Integrations can be excellent partnerships, but they work best when the legal agreement is as thoughtful as the technology itself. Happy integrating. And that concludes our Free Flow update. Thank you for joining us today. For more information, please visit our website at orensteinlegal.com and navigate to the podcast page. Remember to subscribe or follow Free Flow on Spotify, Apple Podcasts, and YouTube so you never miss an episode or update. This podcast is for informational purposes only, is not legal advice, and does not create an attorney-client relationship. Thank you for listening.